Welcome to the Injustice Anywhere podcast.
Tonight we'll be discussing the Jeff Havard case with Attorney Jen Fitzgerald and Advocate Lori Howard. Jeff Havard is one of our closest featured cases at this time. It's one that I'm working on personally. Jeff currently sits wrongfully convicted on death row in Mississippi for the murder and sexual assault of his girlfriend's 6-month-old daughter, Chloe Britt. The truth is, the infant slipped from Jeff's arms while lifting her from the tub, causing her head to hit the toilet. New expert evidence supports Jeff's claims. Chloe's death was a tragic accident, not a murder. Jeff Havard is innocent. Learn more about Jeff's case at freejeffreyhavard.org. Please be sure to visit the Facebook group page to post any questions you have tonight that you'd like to answer it on the show. We've done several shows on this case over the last couple of years when we were on Blog Talk Radio. We've discussed the sexual assault charge thoroughly. This charge has been completely obliterated at this point. The charge resulted from a misdiagnosis made by the ER staff. They wrongly concluded that a dilated anus was a sign of assault, when in fact it's a normal occurrence observed in infant death. The defense learned 12 years after the conviction that the state's expert had tissue sections under a microscope, and he found definitively that there was no evidence of any sexual assault. This is a topic for another show. It's a clear Brady violation. The prosecution withheld this evidence for over 12 years, but the only expert to ever analyze any evidence in this case has come out and stated that no sexual assault occurred. So that evidence is 100% debunked. Jeff received the death penalty because the prosecution claimed the infant's death occurred while the defendant was in the act of committing a felony. The court argued that Jeff shook the infant to death while committing a sexual assault. According to the prosecution, the cause of death was shaken baby syndrome, or SBS. We know that the sexual assault charge has already been disproven. The focus is now on SBS. And a recent court ruling focuses on the same topic in Jeff's case. The Mississippi Supreme Court has granted permission to Jeff's defense team to request an evidentiary hearing based on the fact that the science of shaken baby syndrome has now changed. This is an important development in Jeff's case. In fact, it's the first real break in the case in over 12 years. I would like to introduce our first guest and get started with this discussion on SBS. Jennifer Fitzgerald is a criminal defense attorney in Rhode Island. She's also a member of the Injustice Anywhere Advisory Board. Jen has studied Jeff's case for several years now, and she's an outstanding attorney and also a repeat guest on the show. Hi, Jen. Welcome back to the show.
Hey, Bruce. Thanks for having me.
Hey, very happy to have you. Now, as I mentioned, there's been a significant development in Jeff's case.
Correct.
Can you put it in layman's terms for our listeners? What does it mean to be granted permission to request an evidentiary hearing, and what procedures can we expect to follow?
Well, basically, right now, Jeff is in pretty much the best position that he's been in throughout his post-conviction process. He was convicted in 2002, and his direct appeal, which is his first appeal to the Mississippi Supreme Court, was denied, I think back probably about 2006. So he has essentially been asking the Mississippi Supreme Court to overturn his conviction ever since then. And essentially, one way for that to be done is for the court to send it back to the trial court, which is the court that obviously convicted Jeff. And the court has finally, has finally agreed to do that on a pretty substantial issue that is a brand new issue that he has not argued or raised in the past. And that essentially is that the science that convicted him, the science of shaken baby syndrome, is not all that it was, I guess, cracked up to be at the time that Jeff was convicted back in 2002. And that given what we know now about how infants receive certain injuries and what can cause those injuries, that if we had known then what we know now, Jeff never would have been convicted. And that's the issue, the sole issue that the Supreme Court has agreed to send back to the trial court. And just sort of to put it in more layman's terms, what I mean by send it back to the trial court is that the Mississippi Supreme Court found that there is enough that Jeff presents a clear enough issue that he could potentially receive relief as the basis of that issue can go back to Judge Johnson, who was the judge that presided over his trial. Judge Johnson can do pretty much one of three different things. He can, number one, just say, read the motions or the memorandums that have been filed by Jeff's defense team and those that are filed by the prosecution, and the affidavits from the various doctors that are attached to them, and make a decision straight out and say, I'm going to grant him a new trial, or no, I'm not going to grant him a new trial. The second thing he can do is he can grant him an evidentiary hearing. And that happens when, if Judge Johnson, for example, read the memorandums, which is essentially Jeff's argument why he should get a new trial, why his first trial wasn't fair, and read all the affidavits from the various doctors that Jeff has found to say, that this science is not correct, the science that he was convicted on. And if he still has some sort of hesitation or some questions and something that really needs to come out by putting the doctor on the stand to clarify some issues, then he can grant an evidentiary hearing. And they would call the doctors to testify, and both sides would get to ask questions. And then after that, Judge Johnson would decide whether or not, on the basis of that testimony, to grant him a new trial or not to grant him a new trial. And the third thing he can do is just, without an evidentiary hearing, looking at the arguments by both sides, just find that there's just not enough and basically deny Jeff's motion for a new trial. So that's what you're really looking at here. It's not that they have to get an evidentiary hearing in order to gain relief, but that's probably the most likely thing, I would think, that would happen at this point.
Now, when will Jeff's defense team be filing this request?
There's no real rigid deadline that I'm aware of, but I would assume that they would file it sometime, in the next few weeks, I would think. But given the importance and just this opportunity that they have right now, I'm sure that they're, crossing all their T's and dotting all their I's and making sure that they, check and double check and triple check everything, because it's a real opportunity. It's rare that somebody on death row is granted an opportunity like this where they can bring these kind of issues up and have them carefully looked at. So I would say within the next few weeks they should be filing.
Now we're at the state level now. If this is not granted, is this something he can also take to the federal level?
Well, where we're at right now is, let me just back up a little bit. Jeff has filed several petitions in the past, and they've all been denied. And as recently as, I guess, last year or the year before, he had essentially exhausted all of his state appeals. He had been through the system, the appellate system and post-conviction system, and there was nothing more he could do in state court. So he filed in federal court. While the federal case was pending, this issue of this new evidence that the science, quite frankly, just isn't all it was cracked up to be, that issue sort of got brought to light. So they sort of paused the federal proceeding. So that is still actually pending. He still has a case up in federal court that's just kind of been paused, and we're waiting to find out what happens in state court.
And they just hold on to that until the state decides what it wants to do.
Correct. It's called stay and abate. They basically just sort of stayed everything that's going on in federal court because a new issue has come up. And basically, in order to challenge a state criminal conviction in federal court, the state gets the chance to be the one to look at it first. So you have to go through the state court on every single issue and give the state court a chance to grant relief or grant you a new trial if they want to. And if they don't, then you can go to federal court. But you have to go through state court before you can get to the federal court on any issue.
And this includes any time anything's amended or anything is added to any motion whatsoever?
Right. It's you basically have to give the state court the first shot because it's a state court conviction.
Okay.
So, and there are ways that, without getting into too much detail, there are ways that if the state court denies your claim on the merit, it prevents you from bringing it in federal court. But that's a little bit more complicated. But you just essentially have to go through the state court, let the state court have the first opportunity to decide if they're going to grant you relief. And if they don't, then you get to bring that in federal court. So we've got some a lot of issues actually pending in the federal court right now. This new issue about shaken baby syndrome and the science behind it sort of came to light, I think it was in the June of 2013, if I'm not mistaken. And what happened is the medical examiner, Dr. Hain, who had testified on behalf of the state at trial, he had conducted the autopsy in this case, and he's the one that testified at Jeff's trial that it was his opinion that Chloe, the child, had died as the result of a violent, forceful shaking. He essentially said that he had found all of the symptomology, the physical criteria that fit with what he referred to as shaken baby syndrome, and that was what he determined to be the cause of death. That doctor, that medical examiner, was interviewed by Jerry Mitchell of the Clarion Ledger, and Dr. Hain told Jerry Mitchell that he had essentially changed his opinion about shaken baby syndrome, pardon me, and really sort of for the first time said that he no longer holds the same opinion on that topic that he did years ago when he testified at Jeff's trial. I think the Mitchell's article said that he has disavowed now his original finding as to the cause of death, which, of course, when Jeff's lawyers saw that in the newspaper, they immediately contacted Dr. Hain and said, "Can you explain this to us a little bit further? Have you changed your opinion about what caused this child to die?" And Dr. Hain said that yes, in fact, he had, and that's what prompted this this newest issue to go before the court.
Okay.
So,
now, just to make it clear, Hain is the only expert to analyze this evidence for the court on either side, correct?
Yes. There were what you had at Jeff's trial was you had the treating physician at the emergency room because the child had been rushed to the emergency room with a head injury, and you had the treating physician and several nurses that were at the emergency room at the time that all testified, and they testified to various medical, technical type things that only an expert is allowed to testify to. For example, the pediatrician at the hospital testified that she saw what's called retinal hemorrhages in the child's eyes, and she specifically testified that there's only one thing that can cause that, shaken baby syndrome, and that was some pretty important evidence or pretty important testimony because that essentially precluded or prevented the jury from even considering Jeff's version of events, which is that that he had tragically and unintentionally dropped the child, and she had smacked the back of her head on the porcelain toilet seat. So when you've got a doctor saying, this only happens in cases of shaken baby syndrome, clearly that's something that an expert would have to testify to, and not, your average lay person isn't going to get on the stand and be able to say something like that.
Sure.
The problem is that the state didn't proffer them as experts, which there's a whole there's a whole list of requirements that you sort of have whenever you have an expert testify at trial, designed to make sure you don't have basically a quack up there, just saying, here's my expert opinion, and relaying all kinds of information that's really been unproven or that isn't the general consensus in the scientific community. There's a whole vetting process, and that never happened. So we don't know what this pediatrician's experience or background or training was, or whether she's ever been, to a shaken baby seminar or anything like that. And that's really not supposed to happen. It unfortunately happened in this case. And Jeff didn't have his own independent medical expert to say, hey, that's not true.
Right.
And the difference now is that what Jeff's lawyers are essentially arguing is, in this particular case, even if Jeff did have his own independent medical expert, they couldn't have necessarily said, hey, that's not true, because we didn't know in 2002 just, how much this can happen in accidental falls. In other words, we didn't really know that this is not the only time that this can happen, that kids can fall from heights of 3 feet and smack their head. And
science has learned a lot over the last 12 years. We've seen this in a lot of cases, similar things like with fire experts misdiagnosing fires, and DNA was unavailable in the past. It's now available today. This is very similar. There's evidence now to show that they were wrong about how they diagnosed injuries to infants.
Correct. And the bottom line is that, if we now know that the science was wrong, and there was nothing that the defendant could have done, even if he had the very best lawyers and the very best independent, defense experts, if there was nothing the defendant could have done to change what the flawed thinking was in science by the general scientific community at the time, but yet we now know that it was wrong, there's got to be a mechanism to correct that, and that's exactly where Jeff's at right now. This is that mechanism, and it's an exception, and it's for newly discovered evidence. And the problem is, or not the problem, but the state's response, essentially, is that, hey, this isn't newly discovered. This isn't anything new. The doctors that Jeff has managed to show his case to, there's been, I think, 5 prominent doctors have come forward, looked at all of the evidence in Jeff's case, and all of them have unequivocally said, hey, this is perfectly consistent with Jeff's version of events, and this was not a shaken baby case. This child did not die from being vigorously, shaken by somebody in a rage. What the state's arguing, essentially, is all of those experts have written papers and have testified in other trials back around the time of Jeff's trial to those same sort of opinions that they're giving now. In other words, Dr. Baden, Dr. Ophoven, I think there was a trial in 2005 that she testified that shaken baby isn't all it's cracked up to be. So the state's position is that, hey, this isn't new. This is something that if you had just done a little more research, or if you had called these doctors to the stand at your trial, Jeff, then, this could have come out at the time of trial. So you shouldn't get a crack at it now. So
it doesn't matter what the truth is. All that matters is whether or not you did the proper research back in 2002.
Essentially, the state wouldn't agree with your assessment, but I agree with it. Essentially, they're getting very technical as far as the procedure goes. But you have to also keep in mind that when Jeff went to trial, Jeff's lawyers filed a motion specifically asking the court to appoint an independent expert because Jeff was indigent. Jeff didn't have enough money to hire attorneys like most people don't in a huge case like this, capital murder trial. And so his lawyers filed a motion asking for the court to appoint experts so that their own people, they could go find a qualified medical expert to look at the autopsy and to look at all of the medical evidence and come to their own conclusion. The court denied that request. So Jeff was never allowed to go find these doctors, to go find Janice Ophoven and Michael Baden and Dr. Nichols and have them give an opinion. So even if the state's correct, even if the state's argument that, hey, this isn't really all that new, they were starting to have these opinions around the time of Jeff's trial, the point is that how was he supposed to get these people when he wasn't provided the funds to hire them? The court specifically ruled that we're not going to give Jeff a independent expert because Dr. Haynes available. They can go talk to Dr. Haynes if they want to, and they want to, really find out what happened in the autopsy and what the evidence shows. And Dr. Haynes, in 2013, told Jerry Mitchell that he no longer feels the same way, that his opinion has essentially changed.
And that's big news. I mean, to me, that should warrant a review for sure.
Well, it has, and that's what Jeff is preparing for right now is essentially a review by the trial court. As I said before, the trial court could look at all of the affidavits and look at the arguments that Jeff's lawyers are making, and he could say, you know what, I don't need an evidentiary hearing. Okay, there's enough right here. I'm going to go ahead and grant him a new trial. And he could do that. The state would get to appeal that, and if he decides the other way, Jeff would get to appeal it. So it would still be, a few steps away from Jeff actually having a new trial, but there doesn't necessarily have to be an evidentiary hearing.
And that's what makes this news very positive for Jeff as far as the last 12 years have gone. Now, I want to talk about shaken baby syndrome, the details of the past compared to now, but first I had one question regarding the evidentiary hearing. Are you required only to argue the approved points, or once you are granted that hearing, can you bring up other details in the case, or is the argument limited to the SBS?
Well, I'm glad you asked that, because in the intro you were talking about the evidence that the state put forth at the trial about the sexual assault versus the shaken baby issue. Jeff had also filed a motion based on newly discovered evidence, also based on some statements that Dr. Haynes had made to Jerry Mitchell during a completely separate newspaper article that had come out on January 19th, 2014, so just about a year later, saying that he never thought the child was sexually assaulted, and that he looked at certain sections of tissue under a microscope, found there was no injury to the child's anus, and that he told that to the prosecutors. And the prosecutors obviously never told Jeff's defense lawyers, and this was certainly news to the defense. And it's pretty shocking that in a case of capital murder, where the state's only expert witness tells them he does not think that a sexual assault occurred. He does not think what the state is trying to prove actually happened. For whatever reason, the Mississippi Supreme Court found, sort of in a one-sentence order or conclusion, that there was no merit to Jeff's claim that information had been withheld from the defense. Now, that arguably can be brought up in federal court if, should that day come, should Jeff lose all of his state matters, he can ultimately, hopefully, bring that up in state court. Federal court has been preserved. But right now, since the Mississippi Supreme Court has said, you know what, we don't find any merit to that argument, this is limited to the science of shaken baby.
Right.
It's interesting, though, because the sexual assault is, given the science of it all, is sort of intimately incorporated into the shaken baby, because what made the doctors and nurses think the child had been sexually assaulted was the child's dilated anus. Anuses not only dilate when people die, as all of our bodies, the muscles just relax and so forth. But it's also a sign of brain injury, which is what happened, when Jeff dropped the child and when she suffered her head injury.
Right.
So essentially, it's the issue is the shaken baby, but I wouldn't be surprised if there's an evidentiary hearing and if some testimony about the sexual assault and lack of evidence of there being a sexual assault is somehow incorporated.
So it's not prohibited to include other information.
Well, it is prohibited. However, if this gets to an evidentiary hearing, I think that the issues are so intimately connected that it's good that
you can weave it in.
Well, some of it's naturally going to come out, I think, as a part of the hearing. But,
so we're not going to talk a whole show on SBS. There's a lot of information out there. But where did they go wrong in the past? What do we know now that we didn't know then?
Well, essentially, shaken baby syndrome is a theory that has been around for, 30, 40, 45 years, something like that. And what it is when children or infants would be presented in an emergency room with an obvious head injury. There was obvious signs of some sort of neurological problem that looked everything like a traumatic head injury. But there was no impact spot, like there was no big lump or goose egg or somewhere that you could point to and say, oh, she must have bumped her head right there. How do you explain a head injury when there's no impact site? So the doctors sort of were stumped, and they figured, or they surmised at that point, well, what else could cause it? It must have been a shaking, because if you shake, so the thinking was, the brain inside the skull gets knocked back and forth, and so the brain is hitting the sides of the skull, and that's what's causing the head injury without there actually being this impact force from the outside. And that's why you don't have any sort of external manifestation of an injury, but you can still have this serious and oftentimes lethal head injury. So what they would look for is what they call the diagnostic triad, which is 3 different things. You'd have retinal hemorrhages in the eyes. You would have what's called a subdural hemorrhage, which is this bleeding underneath the skull that sort of just not in the brain itself, but sort of in the area that the brain's floating around in your head. There would be bleeding into that. And you would also have brain swelling. So whenever you saw those 3 symptoms, and there was a caregiver that was unable to give a really an adequate explanation for why the child was in the condition the child was in, they would figure that, well, it had to have been shaking. And what happened is we realized over the last 10 years that a child really can't be, a human being really can't shake a child hard enough to cause the kind of symptoms of the triad. You can't shake a child hard enough to cause, the kinds of things that they're seeing. And they also learned that children who suffer relatively short falls were coming up with these same symptoms of the triad. In Jeff's case, and what's really important to point out, is Chloe had a big old bruise on the back of her head. I mean, she had a big old bruise exactly where, a bruise might be if a child were to accidentally whack her head on the back of a toilet or the top of a toilet. For some reason, Dr. Hain never included that in his analysis. He never considered it. He never considered Jeff's version of events. So while he found that this kid had died by virtue of shaken baby syndrome, nobody ever asked him, could it have happened the way that Jeff said it did? We don't even know if Dr. Hain actually ever heard Jeff's version of events. So I'm sort of getting off on a tangent, but that's sort of.
But it's important. It's an important point to make that all
Mm-hmm.
avenues weren't looked into. They had a very narrow-minded view, and there was nobody questioning anything they said.
Right, and one of the real devastating things about shaken baby syndrome, devastating from an innocent defendant's perspective, is that it really is. If you've got a doctor up there saying it's shaken baby syndrome, it really is a diagnosis of murder. Because, and what I mean by that is, the doctor is saying that this defendant picked up this infant child and shook him and shook him and shook him and as hard as possible and caused these injuries. That act of shaking a child like that can never be an innocent act. You know, you've got your mental state that the intent or to cause harm.
Absolutely.
Or reckless disregard for human life with that. Okay, so if a doctor's up there saying this could only have been caused that way, then what are you left to do? And in Jeff's case, with no independent expert, with the science being the way that it was, it's no wonder he was convicted. Now we know differently. Now we know that these kinds of things, retinal hemorrhages, do happen in cases of short falls. You know, as I said earlier, that one of the pediatricians had testified, you know, I see retinal hemorrhages. There's only one thing that causes that. And if you're a juror and you see, you know, a woman in a white coat on the stand telling you only one thing can cause this particular symptom, this defendant doesn't stand a chance. And now we know that doctor, quite frankly, was wrong. You know,
right.
Not that she was negligent in being wrong. That's what they thought, really, at the time.
Sure.
We now know differently.
So, I mean, the summary now is that the only expert to testify at trial has now changed his position on SBS, and we have numerous experts that have now come forward. You can find those affidavits from these experts on freejeffreyhavard.org. They're all there. They all say that this was not shaken baby syndrome. That's what the science that we know today. So even if the science, even if, like you said, even if Jeff had an expert back then, things might not have worked out well for him because we were looking at the whole idea of the injuries in the wrong way. I mean, now we know the truth.
Right.
You know, advancements in science have shown us that we were wrong. That's not the first time it's happened.
Now we know that, for example, in order for a child to be shaken to death, the way that you know it was described, the child would have you know, rib fractures where the person grabs them, or they would have significant neck injuries, you know, where the neck essentially gets snapped or you know, severely injured. None of those types of injuries, when those aren't present, then you really have to look at it and say, we know better now.
Right. Well, as you and I tend to do, we've run a little bit long. But I had one more question. Now, if he does get this evidentiary hearing, all of these experts that have come forward to provide affidavits, those are all admissible during this hearing, correct?
Oh, no. The affidavits are not. That would, the evidentiary
They're part of his petition.
Exactly. The affidavits are part of his petition. If the court or Judge Johnson decides, I have a few questions or some more information needs to come out than just what's in these affidavits right here. So then he would grant an evidentiary hearing. And what would happen at the evidentiary hearing is the doctors that wrote those affidavits would get put on the witness stand.
Okay. So to be clear, the court reviews all of these affidavits to decide if he gets a hearing. Exactly.
And as I said, an evidentiary hearing would be great. Outright granting a new trial would be even better, you know, without having to go to an evidentiary hearing. But that,
right.
You know, I think that the chances of that happening are in any case, not just Jeff's case, you know, are really very, very, very slim. But in this particular case, I can't imagine him not getting an evidentiary hearing. I
hate to try to place odds on any of these things because we see so many heartbreaking things happen in our system, but this just looks like a slam dunk to me.
Well, nothing's a slam dunk, just like you
that's what I mean. That's why I said I try not to do that.
Right, but I think that I think that people, you know, really should be wondering why the state is so aggressively opposed to this. Why the state isn't looking into this more themselves?
Sure.
Because This normally in shaken baby cases, you're not talking about having a guy who has his life on the line. And in this case, because of that alleged sexual assault, he's on death row.
The combination of the crime
right.
led to the death sentence.
Right. So you're talking about, is it worth it for us to put these doctors on the stand and hear what they have to say and have them explain to us non-doctors why this was shaken or why it was not shaken? Is Jeff's life, is a human being's life important enough to be careful and to really make sure that we know what we're talking about before we go ahead and exact the most final of all punishments?
Right. Absolutely true.
I think the answer to that obviously is a resounding yes. So.
Absolutely. Well, I want to thank you for being on tonight. I think you explained things very well to people like me that are non-experts. I think you have a great way of putting the information out there so our listeners can at least begin to understand the case, because things do get complicated. So thank you again for everything you do.
Sure, and just want to remind everybody to go to the website, because I think that you have a lot of stuff up there now about Shaken Baby, but we can even put some more stuff up there.
Oh, we do, but we will continue to add as we collect more information on it. Yeah, so please visit freejeffreyhavard.org. Thanks again.
Bye-bye.
I'd like to encourage all of our listeners to visit freejeffreyhavard.org to click on the T-shirt promotion right there on the homepage. We have a great apparel collection now available for Jeff's supporters. You can order T-shirts, sweatshirts, long-sleeve shirts, fitted tees. There are multiple colors. They look great. This is a limited-time deal, so don't procrastinate. Thank you to all those that purchased in our first campaign that ended a couple days ago. That went really well. Please be sure to post photos on social media when your shirts arrive, because we'd like to see all of you wearing your brand-new Free Jeff Havard T-shirts. We're going to bring Lori Howard on the line now to discuss Jeff. Lori is a very strong advocate for Jeff, and she's very close with him and talks to him on a regular basis. And Jeff has suffered a loss recently. He lost his grandfather. I wrote an article shortly after his grandfather died detailing how wrongful convictions cause irreparable damage. And I wanted to have Lori come on tonight so we could discuss how Jeff is coping with that, because obviously as the proceedings took place and Jeff's grandfather was on his deathbed in the hospital and his funeral, Jeff was sitting in his cell. So that's very difficult. And I wanted to have Lori come on tonight just to discuss that. Hi, Lori. How are you?
Fine. Thank you, Bruce. Thank you for having me.
Welcome back to the show.
Thank you.
Now, you talk to Jeff on a daily basis. And I know he continues to go through hard times here with the loss of his grandfather. Can you tell me a little bit about Jeff's relationship with his grandfather, and how is Jeff handling things today?
Well, he went to live with his grandparents right before his, I believe, 14th birthday. And he lived in, once he got older, he lived in a trailer right across the street from them until the accident happened. They went places, they did things together, they hunted, they fished, they went to bluegrass festivals. They were very close as a family unit, his grandmother, his grandfather, and Jeffrey. And we all knew that his grandfather was not doing well, and he was the type of man that would refuse to just sit down and take it easy. He always had to be mowing the grass or doing something, So he had a couple incidents before this. So it was discovered he had congestive heart failure. And on St. Patrick's Day, he made it up to visit Jeff. And I think that was pretty much his final push. That was all he had in him, was to go see Jeff that day. And not the next day, but the day after that, he went into the hospital, and he was not real coherent. I'm not sure if they had him on medication, but I believe so. So Jeff didn't get to talk to him as much. But on the day of the 26th, his grandma told him he wasn't talking to anybody, and he said, well, I want to talk to him. And he spoke to him, and he told him that he would always consider him his father, and that, he was his son. And later that night, he passed, actually the next morning he passed away. And Jeff's biggest regret is that he didn't call 10 times that day. But yeah, he and the irony in this also is that the Mississippi, Jeff's grandfather passed on the 26th, and the Mississippi Supreme Court unanimously votes to give him leave to file in the trial court the next day. And so after all those years of waiting,
his grandfather never heard the good news.
Yeah, he never heard. Well, I believe he knows it. I have to believe that. I don't know if Jeff believes that, but I think he does. And ever since then, Jeff has just been beside himself. The state, a wrongful conviction takes a lot from you, and it took away 13 years that he could have been, helping his grandfather as he got older. It took away their ability to go hunting and fishing and doing the things they like to do. It hurts him, and he's still, every morning he wakes up, and that's the first thing he thinks, that his grandfather's not there.
Now, how's his grandmother handling all of this? Is she still able to visit?
She visited today. Yeah, she's visited twice since then. They were on lockdown for the last visit. Like, all of the Mississippi prisons were on lockdown, so she couldn't go to the last visit, but she went today. And she's doing okay. There's so much to do when a person dies, and he had just turned 84 on the 19th of March. So, and he was buried 2 days before their 63rd wedding anniversary. So it's a real shock for her. All of a sudden the person that's been by your side all this time is gone.
Sure.
And she's such a lovely woman. She's such a wonderful lady. I love her dearly. And there's so much to do though. But Jeff's Aunt Marilyn lives really close by, and she's been helping her as much as she can. Her husband had died, so she's been through this before. So she's okay. She's just kind of frazzled,
right,
with all that there is to do. But she still makes time to talk to. Well, actually, it's usually me and Jeff and Miss Ruby on the phone together.
Okay.
And we talk, and she tries to keep cheerful. I usually call her at night because I'm afraid she's, lonely.
Now, I wanted people to hear these stories because if you're guilty of a crime and you're sitting in prison, it's a hardship for the entire family as well as yourself. But that's a punishment. That's a price you pay for the crime you committed.
Absolutely.
When you're innocent and you're sitting in prison, I can't imagine the thoughts and the feelings and the hardships that these families of all the wrongfully convicted are going through. And Jeff is fortunate to have the support of his family. His mom, Cheryl, his sister, Paige, they both advocate strongly for Jeff.
Right, right.
His grandparents visit regularly, and they're incredible supporters of Jeff. And they've all been kept away from him for 13 years, all because of a wrongful conviction that is incredibly clear now.
Well, that was his biggest fear, that he would lose one of his grandparents before this was corrected. So that is exactly what happened. And now, as strong and as healthy as his grandmother is, he worries about that too, because if he doesn't get this evidentiary hearing, which I can't see how he couldn't, it would be a couple years before he would get back to the federal level.
Right. The time frames in between these decisions are very lengthy, and it adds on to years and years and years. Every time there's an adjustment or a denial or a step to the next level, our appeals system is incredibly long and drawn out. And we can keep going back and saying it, but Jeff was convicted in a matter of a couple of days. A jury deliberated for a half an hour, just over half an hour. And now it's 13 years down the road, and we're still watching the appeal system slowly chugging along here. It's a whole different system once you get past that first trial.
The jury selection to sentencing was 12 hours, 12 business hours, for a capital murder trial. And his defense attorneys called not one witness except for the guy who took the sexual assault kit, that did the sexual assault kit on him, and the guy didn't even remember Jeff. So he had no defense. He had no attorneys defending him. He had, prosecutor that saw these attorneys weren't going to defend him, and he took some great liberties. And there Jeff sits.
It's very important for people, if you're watching trials, don't fall back and say, oh, it's not a big deal. He has an appeal. We have an appeal system. That's not the way it works. You look at other cases that we've followed over the years. Look at Ryan Ferguson. There's nobody that could be possibly more innocent than him. He lost 11 appeals over 10 years before he was finally freed. That's our current appeal system. We can convict somebody and put them on death row in a half an hour, but it takes 20 years to get them off of death row if they're innocent.
I think the thing that we need to start focusing on, you have to focus on getting these guys, especially death row inmates, out. But we have to focus on accountability in the courtroom, because as long as there's immunity for prosecutors, it isn't going to stop.
That's a very important point. It's absolutely true. And that's just another coincidentally issue that came up in the Ryan Ferguson case. The prosecutor was allowed to lie right in the courtroom. He lied to the face of the jury. But when he was put on the stand on appeal, he couldn't lie anymore because he was under oath. That's just how the system works. But we could do a whole show on that. Right.
True. Jeff right now is holding up pretty well. We talk a lot about his grandpa. That's how he's dealing with his grief. He was beside himself during the whole, as soon as his grandfather passed and through the funeral process and the first couple weeks, he was just beside himself. He was angry,
sure,
and sad, and 10 million emotions rolled into one. Now I think his avenue is getting it, talking about things they did. So I hear a lot of stories. He and his grandma tell a lot of stories together, and I get to listen. So he's dealing with it, as he has to. He has no choice.
I've spoken with him a few times since his grandfather's passing, and I'll be honest, I just sit and let him talk, because he wants to talk about his grandfather, and I think that's helpful, but it's also very sad, because I know that he's hurting. So I want people to keep Jeff in your thoughts as we move forward here and hope for positive things. Hopefully he gets a hearing.
I pray he does.
Well, thanks for coming on and giving us an update. I know that you advocate incredibly strongly for Jeff, and I know you're going to keep doing that until the day he walks free. So thank you for everything that you do. Thank you, and tell everybody buy a T-shirt. That's right. Everybody's got to sport their T-shirts, and we want photos. Take pictures and put them on Facebook when your T-shirts arrive. It's a great way to show support for Jeff. Yeah, he needs it. And for him, it would be great, because he finds out how many people support him, with Christmas cards and things like that, and he's just astounded. And I keep telling him, you have a lot of support, but for him to see it is another thing. Right. He's very grateful for the support. Well, thank you, Lori. We'll continue the discussion on Facebook. Okay. Thanks. You. Good night. Good night. Before we sign off tonight, I would like to highlight developments in a couple of our featured cases. Last week, I intended a hearing for Jamie Snow. Jamie was convicted in 2001 for the 1991 murder of a gas station attendant. There was no physical evidence of any kind to convict Jamie. His case was built on faulty witness testimony that, if you follow this case over the years, has now been completely demolished. Jamie Snow should not be in prison. Please visit freejamiesnow.com to learn more about his case. And I wrote an article on the recent hearing from last week that can be found on the top of our homepage on that top picture slider there. Scroll through there. You can find an article on Jamie Snow to get up to date on that hearing. It's an important case. People should be following it. He's clearly innocent, and it's time to correct that wrong. There's a hearing scheduled for Friday, June 5th, 2015, to decide if Russ Faria should be granted a new trial based on the finding of new evidence. He is convicted of murdering his terminally ill wife, Betsy Faria, in 2011. Faria's conviction was shocking because he has a rock-solid alibi. 4 witnesses testified that Faria was with them watching movies at the time of the murder. Gas station security cameras and a fast food receipt all confirmed Faria's whereabouts that evening. I wrote an article on this upcoming hearing as well that you can find on that top picture slider on our homepage. So please check out that case as well. That's another one that people really need to follow. You learn a lot from each case about wrongful convictions and how they occur. They're all unique, but there's also similarities that we can all learn from. And last but not least, please take a moment to click on the Club 22 logo at the bottom of our homepage to learn more about Lauryn Hill. Once you do, I think you'll find that you may need to help her cause. I know I certainly did. Join us again next week, same time and channel, right here on Spreaker Radio. Thank you for tuning in. Good night.